Hello, my name is Kate Jackson and I work for the Bodleian Law Library. In this session we'll be looking at primary and secondary legal sources. We're going to cover the difference between primary and secondary legal sources and why this is important, and then we're going to look at each in turn. With primary sources we're going to look at legislation, and then we're going to cover case law. These are the two most important primary sources you'll probably look at. And then we're going to move on to secondary sources, which mainly involves textbooks and articles and how to evaluate these. So first of all, what are primary sources? Legal research relies upon the use and applications of primary sources of legal material. They contain the law itself. Primary sources are those that are direct, authoritative, and are not influenced by anybody's opinion. The main examples you are likely to find are legislation, treaties, case law, but occasionally you'll come across things like parliamentary publications, which are also classed as primary sources. They are free from opinions and are usually prepared as a necessity for most jurisdictions. In comparison, secondary sources are not the law itself. They are opinions, commentaries, and discussions of the law. They are very useful for building an opinion or description of the law, and are useful as a starting point for legal background. They do not have the same value as primary sources of information, and the most likely examples you're going to come across are textbooks and articles, but also law reviews and encyclopedias as well. So let's look at these in turn, starting with primary sources. If we look at legislation first, how legislation is produced depends on the jurisdiction or the country. For example, in the UK, legislation is itself split into primary and secondary legislation. So acts passed by Parliament is classed as primary legislation, and statutory instruments are secondary legislation, and they provide more specific rules and regulations. And you'll come across both of these if you're actually researching UK law. However, in other countries, legislation can be in the form of codes that fall into specific topics, for example, civil or criminal. In other countries, you also might find there's state legislation, which governs the laws within a particular state or part of the country, and federal law, which essentially covers the whole of the country. Another thing to be aware of is there are also international conventions and also overreaching bodies that might affect the law in your particular jurisdiction. For example, the European Union for the member states of the European Union, including the UK. In terms of finding this legislation, most legislation is published by official publishers for that particular jurisdiction, in either hard copy and or electronically. In order to find a specific piece of legislation, you're likely to need a little bit more information than just the topic. You are likely to need the title and number, and sometimes a year, depending on how the legislation is published. Searching by subject is particularly difficult with legislation. Essentially, legislation is not worded in natural language, and so you might be better off looking at secondary sources if this is the route you want to take. Most legislation can be amended over time, so you need to make sure that you find a source that includes amendments, or at least points to amendments, so that you're aware of the current law. In terms of sources of legislation, a lot of legislation is available freely on the internet. Some examples are the legislation.gov site for UK information, and this is as amended, and it's amended regularly. There are also others such as OSLI for Australian legislation and EURLEX for European Union directives and regulations. Most subscription databases will have legislation included as well, and these are preferable to the free sources mainly because they're updated more regularly, and they do have additional information on there as well, which can be of use when you're doing your legal research. If you have access to these, then do use these in preference to the free sites. Moving on to case law. Case law is a very important primary legal source, especially in countries that have a common law system because of the doctrine of precedent. Case law usually consists of reports of cases that have been published in a law report series. And as with the legislation, it's worth noting the jurisdiction of a case that will have bearing on obviously how you use it within your argument. According to the doctrine of precedent, a court is bound by decisions of the court above it, and usually by a court of equivalent standing within the jurisdiction. Superior courts have the power to overrule decisions of lower courts, and in certain cases to overrule their own decisions. It is therefore important to know which court a decision was made when you're actually researching the law. You can use a decision from lower courts or from a different jurisdiction as persuasive precedent rather than binding precedent, but you do have to be aware of this when you're actually choosing case law to back up your legal arguments. Persuasive precedent is often argued when there are no similar cases, for example, in a particular jurisdiction. Another reason for use persuasive precedents is in new areas of law that may not have had sort of a significant case law decided on that point. Case law sources are usually in the form of published law reports. When you're researching case law, it is important to understand any system of law reporting in that particular jurisdiction. Some countries have a national or official law reporting system. For example, in the US, there is a national reporter system. Understanding a system will actually help you find case law and actually reassure you that you've not actually missed any sort of important law report system. In the UK, there's a semi-official series of law reports called The Law Reports, confusingly, which started in 1865. However, there are older cases within UK law that you might come across, and they're usually reprinted in something called the English reports, and this goes back to 1215. However, on top of this, there are also a large number of commercial and subject-specific law reports that you'll come across. And so it's worth bearing in mind that a case can be reported in a number of different law reports. They're the same judgment, but in different places. The other thing to note is that not all cases are reported. In the UK, for example, only cases that are legally significant are reported in a series of law reports. And depending very much on whether it's in the semi-official series or whether it's in a commercial series, depends on the criteria as to why that law report has been included. Although only a small percentage are reported in the hard copy sources, because of the increase of electronic sources, this has meant an increase in the number of unreported judgments available for you to view online, mainly because of space. These consist of just the judgment, however, and do not have all the significant parts of a law report, and that's worth bearing in mind when you're doing your research. Finding law reports depends very much on jurisdiction in terms of sources that you would use. But generally speaking, if you're looking for a specific case, then you would probably need to have a full citation, or at least part of a law report citation. This slide shows a breakdown of case citations, but for the purposes of finding a case, then most electronic sources will allow you to just cut and paste the whole citation and will actually find you the case that way. However, you might find that whether there are different parts of it that are incorrect or case names are actually not spelt correctly, then you might have to do a little bit of searching. If you're looking in hard copy sources, the citation becomes a little bit more important, and you will need to know what abbreviation stands for and use the year and volume information as well as a page number reference. If you're unsure about how to do this, hopefully this slide will break it down so you know where to go to in the hard copy. In terms of where you actually can search, most law reports are available in hard copy, and so you can check whether you have that hard copy series in your library. However, a lot of law reports are available electronically now on subscription databases. So do check what you have access to when you're doing your search. There are also free resources available on the web. A number of the legal information institutes that we already mentioned in relation to legislation also have case law, although they tend to be just the judgments and not the added extra information. If you were looking for US case law, there's also Google Scholar, which does have a very good collection of US case law material. One of the first things a law student needs to learn is how to navigate and interpret a law report very quickly. It is more than just a judgment. It starts obviously with the party names, the judgment dates, the judges' names, but then moves on to catchwords, head notes, summary of the judgment, and then finally on to the judgment itself. You'll also find as well with some law report series that there are summaries of the arguments of counsel as well. So getting to know your way around a law report is very important so that you actually know which part you're looking at. These few slides go through the anatomy of a law report, and you can see as we scroll through that essentially you can actually have to scroll down many pages before you find the judgment. A confusing aspect of this is that there is sometimes no significant sign that a judgment has started, so you have to sometimes read very carefully Sometimes it's just a judge's name. Sometimes it actually says the judgment of. So do be aware, and in this instance, then practice and careful reading is all you can do. In terms of actually reading the judgment, which obviously is probably the most important part of a law report, it's worth noting that they can be quite lengthy, usually depending on the date of the judgment. The whole of the judgment is important, but not all of it is classed as the law. The ratio decidendi is the part of the judgment that is binding. Everything else is classed as obiter dicta and is not binding, but it can be useful because it can be persuasive. When you start out, it can be very, very difficult to actually establish what the ratio is. On top of that, older cases may not separate the two out, and so again might not be very clear to you. It is also a little bit difficult where there's more than one judge, which often happens in the higher courts. Try looking for the abstract principle of law in the judgment. Again, this might take time, it will take practice, but textbooks and other secondary sources can help in this regard if you can actually get the case discussed in your source. Another confusing aspect when reading law reports is that higher courts often have more than one judge, and they do not have to agree before a decision is binding, and that's why most will have an odd number. Those that do not agree with the majority are called dissenting, and the judgments from these judges do not form part of the law. So it's worth reading carefully to make sure that the point you're not relying upon is one from a dissenting judge. So that's primary sources. Now we're going to move on to have a brief look at some secondary sources. Secondary sources can be useful as a starting point. If you're not familiar with the area of law at all, then primary sources can look a little scary. It also helps explain primary sources or build on knowledge of primary sources, and can act as a lead to other sources as well within footnotes. Textbooks and articles are the most common secondary sources you will come across. And generally speaking, they are not seen as authoritative or to be used as authority when you're creating your legal argument. There are some very authoritative textbooks, but generally speaking, always try and rely on primary. In order to find textbooks, you would usually use your library catalogue and use subject search to find the broad topic that you're researching the law on. Obviously within this, the textbooks, there are indexes and table of contents to actually help you find the relevant section to find the legal background. From this, you would obviously then use footnotes to find cases and legislation relating to your topic. It's worth noting to check the publication date of any textbook that you do use and wish to rely upon, and make sure that you try and update it with articles or primary sources, as textbooks can often be out of date even if they're only a few years old. Articles can also be a good source of legal discussion. Searching for articles by subject is best done via a journal index rather than going to individual journal titles. Indexes will have abstracts of articles and sometimes links through to the full text. Larger subscription databases also have collections of journals as well, so check what access you have via your databases. There is also Google Scholar, which is a free articles index and is definitely worth looking at. It's important with secondary sources to always evaluate your source. With primary sources, your main concern is whether the case is still in force or legislation is still in force. But with secondary sources, you also need to make sure that the information is reliable. For example, is it on a reputable database? Is it written by someone who knows the subject very well? Is it updated regularly? And is there any reason for bias? If you're unsure about a source, try and verify your information elsewhere, or ask a librarian, if available, for advice on a particular source and whether it's reliable or not. I hope you find this session useful. Thank you very much for listening.